Good afternoon to everybody on the East Coast, and good morning to those on the West Coast or somewhere in between. This webinar is SCA Compliance Challenges in a COVID-19 Environment. My name is Nichole Atallah, and I'll tell you a little bit more about myself in a minute, but we are with the law firm of PilieroMazza. We're a business law firm. We have clients across the United States, many of whom are government contractors. And we have a broad range of service offerings, and they're all listed here. But Sarah and I practice in the labor and employment practice group. As I mentioned, I'm a partner in that group, and we practice in a broad range of areas. A lot of what we do focuses around compliance for government contractors, which is fitting for today's webinar, which is how are we going to deal with prevailing wage issues, particularly the SCA, when we have all of this other stuff going on. I'm going to hand it over to Sarah to tell you a little bit about herself.
Right, so I've practiced with Nichole, and like she said, we deal with quite a few questions about prevailing wage requirements. And between FFCRA, the sick leave and family leave provisions that were just passed, and the CARES Act, we've been receiving quite a few questions about how this all ties in with the Service Contract Act and what employers are supposed to do, how they're supposed to comply with both laws. And so that's why we thought it would be a good idea to sort of summarize the questions we've received and some of the thoughts we have for how to practice the most safe compliance moving forward. And so I'm looking forward to talking about it.
Yeah, so let's do a brief overview of what we're going to talk about. We do encourage you to submit your questions. We already have a couple coming in, which the question that came in, I think, is the question du jour, which is all about how do we administer health care and other benefits under the SCA to stay SCA compliant with everything that's going on. So we are going to talk about that in a little bit. We kind of reserved an hour for this webinar, even though the content probably isn't going to take us the full hour. But we wanted to do that so that we have plenty of time to answer questions. Again, we can't give specific legal advice. We don't know the specific facts of your case. And as we go through today, you'll understand why the facts of your situation are really important. But to the extent that you have a general question, we're happy to try to tackle it. If we don't get to it today, then we will try to get back in touch with you. And if you have a very fact-specific question, obviously we're happy to set up a time to talk, or you can contact other counsel that you might have a relationship with. But we have to give you the lawyer disclaimer that this isn't legal advice. So in addition to talking about the impact of FFCRA on SCA compliance, we're also going to talk a little bit about the CARES Act and what's in the CARES Act and how it can impact SCA compliance. We also want to talk a little bit about furloughs and layoffs and how the SCA and prevailing wage can be implicated there, audit risk and exposure to audits in this environment. Although the webinar won't particularly focus on giving you the 101 on FFCRA or the CARES Act. What we've assumed in going into this webinar is that you have some basic knowledge of the SCA and some basic knowledge of FFCRA and CARES. So we'll touch on the requirements or benefits of each of these acts as we go, but this isn't really designed to be a deep dive on any of those topics. We have other content that is a deeper dive on those topics. And you can submit a question if you're absolutely lost, and we're happy to back up a little bit if we make an assumption that it's a little bit confusing to anyone. And with that, we're going to dive in with just a general overview of FFCRA.
So FFCRA, and like Nichole said, this is not intended to be a comprehensive sort of tutorial on all things FFCRA. That said, it is important to sort of cover some of the broad requirements just so we have a good understanding of where exactly they intersect with the Service Contract Act and how employers can be sure to comply with both requirements. So for those who don't know, FFCRA was passed in mid-March by Congress, and it provides, effective April 1, required sick leave and family leave requirements for employers who have employees with fewer than 500 employees. Generally, that's sort of the reverse of what you see. You're often going to see bigger employers being subject to heightened scrutiny or heightened requirements. The thing to think about here is generally, first of all, the government is paying for a lot of this leave. And so it seems that they wanted to make sure that they didn't overpromise and overspend on this. The other thing to consider is that often when you have employers who have more than 500 employees, they're going to be providing, in an ideal world, additional sick leave and PTO anyway. So hopefully those employees are covered. But important to remember that these requirements do not apply to employers who have more than 500 employees. The law is temporary in nature. What that means is that it has a sunset provision that essentially closes at the end of this year. So December 31st is when we are going to be no longer required, assuming that there aren't any changes, to provide the leave. And it has certain requirements that I'll just touch on briefly that relate to emergency paid sick leave and emergency family leave. Specifically, the sick leave is limited to 80 hours. So that's essentially going to be for full-time employees, 2 weeks of paid leave. And it applies to a set number of qualified reasons for why someone might need to take leave for COVID-19 related reasons. Those are very strict requirements and they apply. I'll just briefly summarize them. Anyone who is subject to a quarantine or isolation order, anyone who has been advised by a healthcare provider to self-quarantine for COVID-19 related reasons, and anyone who is experiencing COVID-19 type symptoms and is seeking a medical diagnosis. So that's where you're going to have your specific employee. They will be entitled to the leave for those reasons, but it's broader than that. It also applies to any employee who is caring for an individual subject to such an isolation order, or who is caring for a child whose school or place of care has been closed due to COVID-19. There's also a sixth reason that applies to anyone who's experiencing substantially similar conditions specified by HHS, Health and Human Services. It looks like that's just, you have to remember when Congress first passed this law, there were a lot of unknowns, a lot of question marks around COVID-19. It seems like someone had the foresight to say, well, if we have anything moving forward that maybe is similar to COVID, we want to make sure that we cover it and don't have to go back to the drawing board and come up with a whole new law. So they've included this catch-all that is not applicable now, but in the future, if HHS were to include an additional condition that might be covered, that would be covered. And then
this
so
is
that's all the
Nichole.
Yeah.
Yeah, just to be clear, then HHS has not designated any similar symptoms. So that's why it's really not relevant at this point in time. Reason number 6.
Important to, yeah, they have to take additional action for that to actually be triggered. And then for emergency family leave, there's really only one reason for why employees might be entitled to emergency family leave, and that relates to child care due to the child's school or care provider being canceled due to COVID-19 related reasons. Yeah, so those are the first parts, just to keep in mind. That's what we're talking about when we talk about FFCRA leave, we talk about the requirements. There are important caps on these requirements. So just because an employee takes leave does not necessarily mean that all of their wages will be covered for the period in question. Generally, we're dealing with service workers, so a lot of them will have their full wages covered by these requirements, but not all. So whenever you're dealing with the employee's own personal leave, that leave will be capped at $511 per day. And whenever it relates to essentially the care of a family member or of a child, it's going to be capped at $200 per day. It's important to remember for those care of children, care of family members, or roommates, if it's someone who generally the employee is close to and has a close relationship with them, they're only going to be entitled to 2/3 their regular wages. And we'll talk a little bit about what those wages entail, whether they include H&W, what we're looking at. Another sort of lesser known fact is that health insurance benefits are included within the FFCRA leave on top of the cap on wages. So if you have an employee, for example, who has to take leave for their own personal reason, perhaps their healthcare provider told them you need to isolate yourself for the next 2 weeks, they would be entitled to up to $511 in wages. And in addition to that, any healthcare insurance that has been provided to them in their regular course of work. And assuming that you stay within those caps, within those requirements, all of this will be reimbursable to you through a tax credit, basically payroll credit that you're eligible or entitled to through the IRS. So it's actually a very nice benefit, assuming that you and your workforce fit the requirements. Nichole, did you want to? I feel like I've been talking a lot. I don't want to take all of the FFCRA.
No, I'm just waiting. I'm just waiting. Talking just a second. Yeah, I mean, so the big issues with SCA Crossover here is kind of the big elephant in the room, which is, does FFCRA require that we pay H&W benefits? So Sarah answered one of those questions that basically said, if you're using H&W to pay for healthcare, FFCRA actually does require that you maintain health benefits. So that's one consideration there. It does not cover things like other benefits necessarily that you would provide with your H&W. So some of this depends on how you put your H&W package together. Let's say you provide for retirement, 401k, matching, things like that the employer normally pays for. It technically it's not paid for by FFCRA. You're not going to get a reimbursement. So then the question is, okay, does the SCA require? We know that Social Security, we know that the IRS isn't going to pay for us to provide that, the 401k or whatever, whatever other types of bona fide fringe benefits that you might be required to pay under the SCA. So what do we do with that? Because we're going to be out of pocket that. We didn't anticipate having to provide this extra amount. And so how are we going to handle it? There is some indication that the DOL may deem this leave not covered by the SCA at all, because it wasn't anticipated to be covered by the SCA, and it's not covered by any SCA leave regulation. However, we do not have any guidance out of the Department of Labor that they will, issue that guidance, right? So we don't have any indication that that guidance is definitely forthcoming. And we don't have any indication of how that guidance will actually read once it goes through the various levels. This is kind of, right now it's whispers that we're hearing. The other issue is that if the national office doesn't cover this, if the national office doesn't specifically say, don't worry about the H&W, and they leave it to each individual regional office or local office to decide, you could have situations where one office gives you a pass and another office says, hey, wait a minute. And while that shouldn't be the case, we know that that's the case with a number of other provisions under the SCA, where different offices in different regions interpret the law differently. And that's with respect to even the SCA regs as they stand. So some of the answer to this question will in part depend on your level of risk. Are you paying, how are you discharging that H&W benefit? So what's your level of risk? So that's what we wanted to really spend some time on today. First of all, you have even and odd wage determinations, right? We are most concerned about those odd wage determinations because under the odd wage determinations, you pay H&W on all hours paid, including leave, up to 40 hours a week. The even wage determinations don't require H&W payment be made at all for time that's not worked. So if you're operating under even wage determinations, which we understand would be the minority of you, not as many of you have even wage determinations, we really aren't worried as much about evens as we are about odds. But if we have an odd wage determination, then we want to look at how you're paying the H&W. How are you discharging that benefit? Cash in lieu, our interpretation of cash in lieu is that because it's going on the paycheck as cash, there is a good justification for including that cash as part of the wage payment and getting that reimbursement from Social Security. So under the SCA regime, it's H&W, but there is no H&W regime under FFCRA, and it's paid in cash as wages, it's taxed as wages. So there's a good argument that the cash in lieu should be treated as wages in terms of reimbursement for the IRS. Health insurance we know is required to be maintained and is reimbursable. So what we're really talking about is retirement, short-term disability, life insurance, those kinds of things. If you have a significant portion of that such that your risk would be high, you might want to consider whether it makes sense, whether you can maintain that benefit or not. There is a good faith basis not to provide the benefit, I think, that it's not leave that's anticipated under the SCA. So I think if Department of Labor investigated, there would be a good faith, bona fide reason why you did not maintain it. But if you don't want to deal with it, and the amount that you put into retirement savings or short-term disability or life is low, you might want to consider maintaining those benefits. The other catch we might want to, sure, absolutely.
I just wanted to pop in one comment because we received a question about it. It's about whether the 2/3 cap applies to health and welfare or health insurance benefits as well as to the wages. And there's nothing in the law that caps the health insurance payments. So as long as you're paying H&W as health insurance, you can receive the full 100% credit based on what you're paying for that employee, regardless of the type of leave that they're taking. Just wanted to.
Yeah, and if you look at the IRS forms on this, you want to keep really good records. You want to keep track of your records because if there's an audit, they can ask you for the justification for the amount of health insurance that you paid for employees. So you certainly want to keep very good records because all you're going to be doing on the Form 7200 or the 941, so the 941 is the form that you file quarterly to pay your payroll taxes. That's where you're going to receive the credit back. If you need it earlier than that, you fill out a Form 7200, and there are specific instructions on the IRS website about how to do both of those things. But really, this is going to be a certification and audit situation, just like your taxes are, right? So you have to make certain attestations that you're doing this right, and if you get audited, they're going to look at your paper trail. So you keep good records as far as the per person cost of health insurance. You also can't take the employee's portion as a credit, right? You're charging that back to the employee. That's not a cost to you as the employer.
It's also important to remember in this context, we had a line on it on the previous slide, but I didn't get to it. You can only receive FFCRA credit for employees who would have been working but for their health or childcare or family care related need. If these employees would not otherwise be working, say they're subject, or the business, your business that they work for is subject to a stay-at-home order, so you're not able to perform work for a contract that you are generally providing work for, FFCRA does not apply. It only applies in situations where these other employees would otherwise be working but for their personal health or personal care need. So that's important to remember. It's just different from when we talk about the CARES Act. But when it comes to FFCRA, you need to think of it as it's specifically the employee's reason for why they're unable to come to work. It's also important to remember if employees are able to telework, then it doesn't apply.
Exactly. So that if somebody can work remotely, then presumably they don't need the leave, right? That's the idea. That's distinguishable. I think there's a little bit of gray area in there when it comes to caring for children or even caring for somebody else who might be ill, where, you know, maybe they can only work half the time that they used to work because they have 3 kids that all need schooling and they're the primary caregiver. In that particular case, both parties could agree that intermittent leave would make sense, and you can work that out, but you both have to agree to it. So that's one option for remote work. But they're both important considerations. You got to be open for business for it to apply, and the employee can't otherwise be working, right? So both of those are important. I wanted to mention Family Medical Leave Act and H&W, because this particular part of the it's not really a part of the SCA, but it has big implications when you're dealing with benefits under the Family and Medical Leave Act and the SCA. So the Family and Medical Leave Act has a provision that requires an employer to maintain benefits when somebody is on FMLA, right? So normally, if we're outside of the SCA context in any business that would normally qualify under FMLA, if somebody goes on maternity leave or is out with a broken leg, the employer maintains the employer portion of the healthcare benefits during that period of leave. There is a DOL opinion letter that says that, hey, we understand that you might not be required under the SCA to pay H&W during periods of FMLA, but you are required under FMLA to provide maintenance of benefits. And so DOL's position is that healthcare, the employer portion, or the portion that's covered by H&W. So DOL thinks about this as that the employer's portion is the portion of healthcare that's covered by H&W. That needs to be maintained while someone is on family and medical leave, right? So in addition to the FFCRA requirement that healthcare be maintained, FMLA also requires that that healthcare be maintained under it when somebody goes on that extended family leave. So that's important to keep in mind.
Nichole, this is a question that we received, and maybe you want to address it here, is how do you, if the employee is not working, how do you know how much H&W to contribute towards their health insurance? Because it's based off of hours worked, right? So isn't that an impossible calculation?
The H&W itself might be, but the healthcare would not be, right? So what we've been telling people is to take an average. So a lot of what's done under the SCA is based on, you know, if you think about vacation or holidays, look at their normal schedule. And if their normal schedule is, you know, 35 hours a week, and then take the 35 hours a week, right? If they were all over the place, you might have to look at an average. So if you decide to maintain all of H&W because you're risk adverse and you don't want to take the chance with DOL, then look back at what the person's normal schedule would have been. Are they generally 20 hours? Or are they generally 40 hours? If they're what we call fluctuating hours, then you want to take a period of time and essentially average it, just like you would we do that for healthcare, we do that for vacation, we do a look back period for the year on vacation to figure out how to prorate it. Again, there's no guidance on this. So we're guessing to some degree, but I think as long as you make a reasonable effort and proceed in good faith, you know, whatever DOL decides to do will have a rational basis, and you won't be in the willful violation pile, and you certainly wouldn't be subject to any debarment proceedings or suspension proceedings because you proceeded in good faith and with some rational basis to do it.
Mm-hmm. We received another question that sort of touches on this, and I'll say what I think. Nichole, you might have a different opinion or different approach, and I think it really, again, comes down to how much risk you're willing to take. If you pay H&W as cash, and have an employee who, say, is absent due to their need to take care of a child who's out of school. Would that H&W paid in cash be capped at that 2/3 rate, or would you be obligated to pay the full H&W value regardless of whether the regular rate is being capped at that 2/3 rate? I think my thought is, if we're assuming that H&W in cash is going to be considered regular wages, then you would have a strong position to state that that's also capped at the 2/3 rate, especially since the wage determination maybe will offer that flexibility down the road. But I don't know if, Nichole, you have a different approach. I think the safest approach would be to pay the full rate, but again, there's no guarantee you'll be reimbursed.
Yeah, and the other reason I think that's a reasonable approach to cap at 2/3, one, the reason Sarah said, right, that we reasonably believe that it would be considered wages. Wages is defined pretty broadly under FFCRA. But the other reason is that because DOL has given us guidance on how to handle exempt employee pay. So normally under the Fair Labor Standards Act, we're not allowed to decrease somebody's salary for partial days work. We have to maintain their salary. So one of the questions early on with FFCRA was, what do I do with these salaried people? Because don't I have to pay them their full salary no matter what? And the answer was that, yeah, that's what the Fair Labor Standards Act requires. But this law specifically allows you just to pay 2/3 of that rate, or to cap the rate at $511 a day, depending on the reason for leave, right? So we could reasonably take that guidance and transition it over to the SCA context, where, yes, we have this law that might require H&W be paid on hours paid, but we're still we're only subject to the caps of the law. So I think that's a reasonable position to take if we try to make some parallels between DOL guidance on the Fair Labor Standards Act with exempt employees and SCA employees. So I think that's certainly acceptable.
Okay.
We also just wanted to note that you shouldn't forget about state and contract specific requirements, right? So, and where this has come up is in terms of things like leave requests and getting doctor's notes and how much time things need to be turned around. And some states, I think Washington State has passed a specific leave law. California, I think, has passed a specific leave law. So, you know, there are different states and contracts that could require, you know, you to be cautious about things like how quickly you can require doctor's notes for things. And so it was just more of a reminder to you all not to forget about state law and how it can be implicated in many ways and complicate things under the SCA as well. So generally speaking, things like we would recommend you stick to your policies about not requiring a doctor's note on the next day. In fact, FFCRA itself doesn't require much of any documentation other than an employee attestation of the reason they need the leave and perhaps the name of the healthcare provider. That doesn't necessarily mean you can't require something, but you know, you want to be reasonable and essentially not deny somebody leave because they couldn't give you a doctor's note the next day.
And recall that this is assuming that you can spare the manpower, and there are some exceptions for people who have less than 50 employees for the family leave requirements. But remember that you're generally going to be compensated for leave that is taken. So to the extent that there's a concern about this impacting the bottom line, assuming you get the right attestations from the employee, you will get this money paid back to you, whether it's through your general payroll deductions or as a reimbursement check from the IRS.
Yeah, I know a lot of employers are concerned about having to wait the full quarter, but you don't have to wait the full quarter if you need the liquid cash before then. If you have a lot of folks that are on, say, family leave, you can get that earlier.
Right.
So we did want to talk a little bit about some other considerations. You can't discipline somebody or discriminate against them for taking FFCRA leave. So, for example, if, you know, at the 2 months from now, you have to make some layoff decisions. Don't lay off everybody that took, FFCRA family extended leave, because we know they have kids and we're going to be dealing with them with schools out in the fall, right? That's not good for a number of reasons. You could have issues under state law because familial status and parenting can be a protected class. I'm guessing a disproportionate of those people would be women. That's an assumption on my part, but I think a reasonable one. And so you're going to have some issues there. So be very careful about, if you have to lay off, add FFCRA leave to your list of disparate impact checks. So you should always be checking when you do a layoff to make sure that one protected class is not disparately impacted, and you want to add FFCRA leave to that list. You need to keep, as all things, and I think we mentioned this earlier, keep good records, right? If you don't have a leave request form, please email us and talk to us, because and Sarah can speak to this as well. It's one of the pivotal parts of FFCRA is to keep track and have the employee attest to the need for leave.
Absolutely. If you don't, and again, we don't know how closely IRS is going to be scrutinizing the credits that people are requesting, but you don't want to be in a position where you paid out 2/3 pay for someone for 10 weeks and then find at some point next year that the IRS doesn't like the information you submitted. So it's important to keep very close track of what those requirements are so that you make sure that you've checked all the boxes. One of the things that we've seen missing from a lot of these FFCRA leave request forms is an attestation that provides that the employee confirms that they were unable to telework or work remotely due to whatever their qualifying reason is. So it's important that you include that in your leave request forms, because if not, it could be one of those seemingly minor omissions that ends up costing a lot down the road.
Yeah, I mean, I would think of this a lot like an IRS audit. So there's going to be, and this goes to the last part of the slide, there are going to be several different ways that this can come up, right? So the first is you're essentially filing something with the IRS. So there's, can I get the amounts of leave reimbursed? And that's subject to audit. And then there are employee complaints about their ability to get leave or it being administered correctly. And those are all going to be administered through the Department of Labor, either through the emergency sick leave will be viewed through the lens of the FLSA enforcement provisions, and then the emergency family leave would be enforced under the FMLA, which is also administered by the Department of Labor. It's just a different standard of regulations. It is important to know that for the family medical leave extension, employers that wouldn't otherwise be subject to FMLA, because remember there are two different rules. Under the emergency leave, you just have to be under 500. Under FMLA, remember we're looking at 50 employees in a 75-mile radius. You would not be subject to a private right of action if you were not otherwise subject to FMLA. So if you are only having to comply with this because you're under 500 and FMLA generally doesn't apply to you, the employee would not have a private right of action under the FMLA against you, which is a good thing for employers. Sarah, did you have anything else to add to this slide?
Yeah, the only thing I'll mention is we've received quite a few questions. A lot of them touch on material that we're going to get to in the next few slides, dealing with furloughing of SCA employees and dealing with CBAs. Don't worry, we will address them. It's just we have them later on in the presentation, so they're coming.
All right.
I think that's it for FFCRA, though. I think that covers.
Okay. We're going to move on. So there are three main provisions that we wanted to talk about under CARES. And we, keep in mind CARES is like 900 pages, and there's a CARES 2, CARES 3, CARES, I heard Nancy Pelosi talking about CARES 4. So CARES is big. So the three, things that have come up in our practice a lot are PPP, the Paycheck Protection Program. And as many of you know, that gives loans up to $10 million to small businesses, which are either under 500 people small under your NAICS code, or you have a exemption under a hospitality NAICS code. So small can not always mean small, right? But you get up to 2.5 times your monthly payroll for that loan. And there's been a lot in the press about PPP, and what we're going to focus on a little bit is how PPP can play into your SCA obligation. There's also Section 3610, which is the program that allows a contracting officer to essentially continue paying you to provide pay to your people when they're otherwise unable to work. And then there's this employee retention credit, which gives generally to $5,000 of credit under the same mechanism as FFCRA, essentially, to businesses impacted by COVID-19. You can't double dip, right? So we kind of have to look at everything, all of these benefits together to determine how we're going to fit all the puzzle pieces together. So if you got a PPP loan, you're also using FFCRA, maybe the contracting officer has said they would be willing to consider Section 3610. You have a lot going on, and we need to figure out, one, what can we use and what can we not use? And then two, how does this impact our obligations under the SCA?
The important thing is to remember that you should not be coming out of this with more money than when you started. So if you have a question about whether you can use two things at once, think about whether it involves the government paying twice for something that you end up really not paying at all, and that should help decide whether it's a good overlap or a bad overlap.
So the one thing to keep in mind under any of these things is that if employees aren't working at all and you're providing essentially some form of paid leave, the same considerations as far as SCA goes will generally apply in that situation as well, right? So for PPP, for example, that would also reimburse healthcare costs the same way. You can use that for healthcare costs. You can use it for payroll. You can use it to cover any number of expenses that relate to payroll, and then some like rent, utilities, things like that, up to 25% of that loan. So the question, if they're not working at all, I think there's a good argument that they wouldn't be subject to the SCA at all. That's different than a little bit distinguishable for FFCRA, because under FFCRA, they're still working, right? So it's a little bit more of a complicated question for me than if somebody is operating under one of these three programs and is not working at all. I think you have less risk that DOL could come in and say that the SCA prevailing wage rates should apply, because frankly, they're not working. They're not working under an SCA contract. You're just maintaining their pay subject to one of these particular requirements. They'd otherwise be laid off. If you continue to have people work and you just, you're still paying them, but you're expecting them to work, I think you have a lot of the same considerations that you did under FFCRA. Would you agree with that assessment, Sarah?
Yeah, the only caveat I would make is, suppose that maybe your specific SCA contract has been stopped, but you have them working back office support, you found something else for them to do. In that situation, even though they are working, they're still not going to be working on that SCA contract, so they're not going to be subject to those same H&W prevailing wage requirements.
And keep in mind,
I don't know if you're
though,
planning on
you
talking.
have to keep records. Yeah, keep good records if you do that.
Oh yeah, definitely keep records of everything. And then you want to also be careful that you're doing the math, because as Nichole mentioned, PPP, you only get the loan forgiven if you hit certain requirements, you keep certain employees employed, and you don't reduce salaries below more than 25%. And so just make sure that you're complying with all the other numbers to make sure that you still get the full loan forgiveness that is right for you.
Yeah. Some common questions that we're getting in this area is, we just kind of covered one of them. Like, if you have a slowdown or a stop in work, then how could that implicate SCA? We're going to talk about furloughs and in a little bit here, and how specifically that could impact you in the SCA world. But with respect to pay, you can apply, keep in mind that you have state minimum wage laws, you have federal minimum wage laws. States usually higher at this point than federal, but they could be the same. You have a government contractor minimum wage for SCA contracts, and then you have your SCA prevailing wage rate. So if you're talking about, for example, Section 3610, I would caution you that if the government's essentially maintaining your payroll, they're probably going to want to pay you at least to pay that government contractor minimum wage, right? And that would also play into if you have a PPP loan, you need to make sure that you can use 75% of that on payroll, things like that. So there are a lot of moving parts, and that's why we kind of said at the outset, this can be very fact specific, but you kind of have to fit the puzzle pieces together. If if you're not working at all and it's not subject to 3610, I think you can arguably either pay them whatever you need to pay them or, lay them off. But you need to at least meet minimum wage requirements depending on that, whatever that minimum wage requirement would be.
We received a question that's essentially saying we have the opposite of a work slowdown. We have an exploding level of effort. I think that really wouldn't impact FFCRA, but it might impact your ability to receive employee retention credits or the PPP loan. So if you're wondering about being eligible under those specific criteria, you might want to consider reaching out to us offline. We can talk about your specific circumstance. We also had a question. Go ahead.
I was just going to say, if one of your problems is people want this leave and we have so much work to do, I have gotten that question. And again, if they qualify, you can't deny the leave. Now, there are certain industries where you could deny the leave. For example, if you use healthcare workers, the healthcare workers are broadly exempted from FFCRA. And so you might be in that situation as well. But if you qualify as covered, you have to grant the leave.
This is a second part to the question that I sort of didn't address, but if you have a lot more labor hours, but it's a fixed price, how do you sort of address that issue with your CEO? I think ultimately you would really need to look at the specific contract and see if you have an argument to make that there's been a change that entitles you to some additional resources.
Yeah, I think that's right.
Just talk to your CEO.
There was also a question about, during furlough, you essentially have people not working, but you guys are maintaining their hourly rate. Do we pay for health and welfare for any hours paid, even though they are not working? And does it affect their benefit? So the answer to that is, I think your risk is relatively low if they're not working at all and they're not getting paid under Section 3610, meaning the contracting officer isn't maintaining their wages. I think DOL would be hard pressed to try to tell you that, that they would otherwise be furloughed or laid off. So I think your risk is low if you decide not to pay the H&W during that amount. If you're paying under, a PPP loan, you're maintaining their pay. You can maintain their, H&W and get it offset. And so you might want to consider using those funds for that. It could affect, if you're not paying the H&W, it could affect their ability to get benefits, obviously. So one of the pieces of that question was, how does it affect their benefits? And, if you're not paying it, they're not going to get the benefits, or they would go on COBRA and would have to pay benefits on their own if they were not otherwise subject to a requirement to pay benefits.
We received another question about FFCRA and its overlap with PPP loans. Technically, you are supposed to use FFCRA prior to using your PPP loan. So if you have employees who are taking qualified leave, that leave should be submitted as a payroll tax credit and then deducted from whatever payroll expenses you might receive under PPP. That's how the law is supposed to be applied. I suppose the question is, how do you show that someone didn't apply for required FFCRA leave that they should have applied for? I think that's going to be a hard thing for the government to find out, but technically that's what the law requires.
Yeah, and you certainly, I mean, you're certifying to a lot of this stuff when you're turning things in. So, I mean, the presumption is that there is this club out there called the, False Claims Act, or, you get IG investigations, things like that. And you might get questions about it. If you have no FFCRA leave on your books, they might ask you, so nobody asked for leave. Where is your FFCRA notice poster? Where is your, so it's really an audit question. I think Sarah's point is very well taken. It's going to be really hard to tell this stuff, but, you are supposed to use FFCRA if somebody requests leave versus just paying them. And different employers, some employers are just going to pay people for the 8 weeks and not require them to do anything. So the employees aren't going to request leave even if they qualify for it, right? So you could handle that through, I think, if you wanted to do some sort of form to employees that says, hey, if you need FFCRA leave, if you're taking care of kids, we need to know that. Things like that would be one way to deal with it.
And there's nothing that prevents an employer from paying more than FFCRA requires. So if you have employees who are subject to that 2/3 cap, you're only going to receive credit for the 2/3, but there's nothing that prevents you from just supplementing that 2/3 with an additional 1/3 that you just feel like paying if you want.
Yeah, and that 1/3 can be covered by PPP. So if you have PPP, you can cover the balance with PPP and get the credit for it for loan forgiveness under PPP. Okay, should we move on to furloughing SCA employees?
Let's do it.
All right, do you want to talk a little bit about vacation payout?
Yeah, great. So if you recall, throw back to all those SCA webinars we've done in the past. SCA requirements apply certain vacation requirements to all employees, and these vacation requirements are, based on employee anniversary dates. So technically, employees only vest in their vacation. This could vary if you have an accrual system. That's outside the scope of what we're discussing today. But technically, once that vacation is vested, that's employees' vacation to keep. There is maybe an exception here where we have a furlough as opposed to a layoff. So for those who don't know, a furlough is generally this idea that we're going to place you on temporary leave, but the expectation is that you will return to work at some point over the next few weeks or months. In those situations where you do have an intent to bring these employees back, there is a strong argument to be made that vacation need not be paid out because these employees are just going to come back and use that vacation. You have to be careful though, because if you don't make it clear that your intent is to have them come back, there could be an argument that you do have to pay out that vacation. So just make sure that you're very clearly communicating to employees the difference, whether they're being put on furlough or whether you're laying them off, and then that will help decide whether that vacation actually needs to be paid out. Another question that we've been receiving is, can I just advance employees some vacation or some leave because they need to, maybe there's been a work slowdown, we're not getting as much work. Assuming that you can afford to advance the leave, that might be a good approach, which kind of allows your employees to get paid, assuming it's not a FFCRA leave reason that they are already getting paid for, but that might allow you to advance them some of their vacation so that they're able to continue to receive a regular salary. I would just recommend that you're careful to include maybe an agreement that makes sure that employees acknowledge and understand that this is an advance and that they have been provided this vacation earlier than they otherwise would have due to some extenuating circumstances.
And that's really so that if you reach an anniversary date down the road and somebody says, or DOL is auditing and says, why didn't you give this person their dump of vacation on their anniversary date? You say because they got an advance back in June. That, you know, I have had DOL investigators tell me before that you still have to give them their dump. But if we have some sort of agreement and everybody's on the same page, it's a lot easier for us to deal with DOL when we have something in place.
Right.
The other thing we wanted to mention is breaks in service. And this goes to a little bit of the point that Sarah was making, that if you're furloughing somebody or it's on a temporary layoff, you know, breaks in service are really supposed to help a contractor figure out how to calculate that vacation amount to begin with. So think about this not as in terms of now, but even, you know, when an employee is dealing with the next contractor, when you take over a new contract, and somebody puts on their application or discloses to you that they were, you know, their periods of employment were with the same employer, and there's this 1 or 2 month period right during COVID-19 where they say they had a gap of employment. You should be following up on that because you might think that that's a break in service, so you don't have to give them credit for any of the time they worked on that contract prior to that break, right? That you're only going to count anything going forward. But we really have to look at the reason for the break. Did they quit and then come back? That's a break in service because when they quit that job, it was permanent. You know, they didn't intend to come back. Even if they ended up getting rehired in 2 months, that's a break in service. However, furloughs and temporary layoffs are not generally meant to be breaks in service. So vacation won't reset at the end of this. You're not going to start at year one generally for purposes of how much a vacation employee is entitled to. So to the extent that you anticipate that it's not going to be a permanent layoff, there will be no break in service in the future until such time as they quit or are otherwise terminated. But, you know, if you lost your contract was terminated for convenience or something like that, and it's intended to be permanent, then there is a break in service and you can justify that. Again, documentation is really important here. So make sure that you memorialize, you know, why the termination occurred somewhere. And maybe that's in the letter to the employee. Yeah, I mean, a lot of you probably are dealing with unemployment eligibility right now too. So we just wanted to simply, I think Sarah might have more to add here, but generally say that it's important in many states to indicate the nature of the furlough or layoff and whether it's intended to be long-term or short-term, because that will not only does it impact some of the things like vacation payout and break in service, but it also can affect unemployment eligibility and what an employee has to provide to unemployment in order to get that benefit.
Right. A lot of employees are receiving, or former employees are receiving, whether it's a furlough or a layoff, heightened unemployment. I think it depends a lot on the state that they're in. Some states have blown through a lot of their budget so far for this, but I think it's at least either June or July, employees are entitled to an additional $600 in addition to what the typical unemployment would be for them, which is giving a lot of employees, in some cases, additional pay beyond what they were making while they were employed. That said, it's temporary. So a lot of these employees, even if they're receiving a pretty good check right now, assuming that they've gone through the process, are looking at a decrease in unemployment come the end of summer.
Yeah. And of course, I can't believe we do what we always do, and we think that this is going to be short, and it's already 2:53. So
we know how to talk.
Let's talk a little bit about collective bargaining agreements. We wanted to kind of contain this a little bit because collective bargaining agreement situations can be very tense, and particularly in light of everything that's going on. And so, first of all, when you're furloughing or laying people off, make sure you are reading that CBA backwards, forwards, and sideways, right? So generally speaking, most CBAs are going to say that you should lay off by seniority, those with the least seniority first in each particular wage classification. So you want to follow the rules for furloughs and layoffs to the extent they exist in that collective bargaining agreement. Most CBAs, if you have a management rights clause that's worth its salt, is going to give the employer the right to otherwise determine when they need to lay off and how many people they need to lay off. The union can ask you for what we call impact bargaining, and that means that if you have to lay off folks, they can come to you and say, hey, let's talk about things like, severance pay, or, how this might impact the workforce, how we're going to do it, how much notice you should give people, things like that. Whether there are any funding sources. You don't have to agree to anything that the union might suggest, but you can't box them out and refuse to talk to them. And generally speaking, I think communication, even if you don't get along with the union folks, communication is a good thing. At least you know what might be coming at you, right? So that's, I think, very important. It's also important to understand that a lot of union contracts read similar to the SCA, and in that they talk about hours paid versus hours worked. This is going to be, whether you have to maintain certain benefits, is going to kind of follow the lines of the SCA analysis we gave you earlier, but it also implicates the language in your agreement and how, and whether you have things like zipper clauses in your agreement, or how the language reads specifically. So, there might be a good argument that the pension payments were not anticipated to be continued under, FFCRA leave, for example, because that was never negotiated. FFCRA leave was never a part of the deal, right?
Just to make sure we're all on the same page. Yeah, I just want to make clear that just because you have a CBA employee does not mean that they are somehow exempt from FFCRA. FFCRA applies whether you're unionized or not, whether you have 8 million hours of vacation already, and you can't imagine that the law would require employees to receive more on top of that. It still is applying to these contracts. So just in that context, I just wanted to make sure that it's clear. That's why we're looking at specific benefits. Yeah.
And it also is a good point. I don't know that we've mentioned it, that under FFCRA, the employee gets to decide what leave they want to use first. So an employer can't make them take FFCRA first, and the employer can't make them take the leave under this that they've accrued with the employer, either under a CBA or otherwise, first. So there's good reasons why I think employers would want to encourage people to use FFCRA first, particularly because there's a sunset provision in December. That's why employees might want to take it, and the employer gets reimbursed for it. But, you don't get to mandate that. So it's a good thing to implement the policy. It's a good thing to shoot that policy over to the union before you just implement a policy, or we're not going to do that. You might have the right in the management rights clause to implement new policies. You might not have an obligation to send it to the union. But I generally think it's a good idea, particularly with everything going on, that you can build some goodwill there. So there's always the question, there's always a tension between what you have to do under the law and what's going to make the path easier. Save your no's for the stuff that you really need to say no to, right? Instead of just being like, the union just says, that person always says no and they don't know what they're talking about. That's a bad employer, right? Be a good communicator, and then save your no's for when you really need to say no. Like the pension payment, $7 an hour, and I've got people on leave for the next 8 weeks. I'm not getting reimbursed for the pension from anywhere. I'm not getting it from the government. I'm not getting it from my client. I can't maintain the pension. Well, then let's talk about it. Do we have a basis to say that this was never negotiated and we're not going to maintain the pension payment? I think that many contracts will have a good basis to say that. But again, you're going to want an advisor to really look at that CBA, because the last thing you need is a huge fight when you are short on resources to begin with. Sarah, do you have anything to add to that?
No, I think that's it. For me, we seem to have covered all our CBA stuff. And I think the questions have died down a little bit too. So
yeah, there were a couple of questions about PPP, I think, at the beginning. We talked about the number of employees. It's 500 employees with their primary residence in the United States. So there was a question about whether that was limited to domestic employees or not. I don't always say domestic because I think that has some, like, they don't necessarily have to be in the United States, but their primary residence needs to be in the United States. And then there was a question about the caps, about whether the caps for FFCRA were 200 or 511 per day or per week, and that cap is per day, not per week. So to the extent we may have misspoke, sometimes we're talking so fast and doing this stuff all the time that hopefully we didn't mess that up anywhere. So give me a second. I'm looking through. Sarah, did you see any questions you wanted to tackle right away? I'm going to leafing through real quick.
I think we got through a lot of them. We had a question about administrative leave that was asking about vacation. I'm not sure if I quite understand it, but if you put someone on paid administrative leave, they might as well just be on like regularly employed, because you're paying them regularly, they're accruing vacation regularly, so that shouldn't change your vacation obligations under the SCA.
No, it generally wouldn't. And they're only, I mean, it depends on how you administer your vacation, but presumably it's not going to affect their accrual calculation or, you know, what they should get. And I don't think it wouldn't be a break-in service unless that's intended to be rather permanent.
So, apologies if we did miss your question. Oh yeah, go ahead.
Yeah, no, there's a question about intermittent leave under FFCRA, and is there a way to calculate insurance? Yeah, you would. The question is, should it be prorated? Yes, you would prorate that health insurance leave, and so you'd have to decide. You know, are people taking that intermittent leave half a day? You know, you look at the number of hours, and I would probably, if you're doing intermittent leave, I'd probably take a look at, you know, the hours in a given month that somebody's expected to work and break down the premium by hours. I have had a number of employers say that it's been very challenging for them to administer the intermittent leave, and I'm sure that payroll hates everyone who makes them do it, but sometimes we got to do it, and it's hopefully for a short period of time. I'm getting to the end. Are we? We are 3:02, so we're over. That's Sarah was trying to cut me off. She was telling me to be responsible.
Information is always good. I support it.
So I'm going to do one last question, and then we're going to tie it up. And so one of the questions was, if the company covers all health insurance costs while the employee is on FFCRA, would the company still need to provide them the H&W payment? And, you know, my sense is that you're going to be fine, but H&W isn't necessarily connected to you cover the entire cost of healthcare. H&W is connected to, you know, how much H&W the employee would have accrued on that leave and whether there's any left over. So I think what we mentioned earlier about level of risk, I think your level of risk is probably low, that you certainly wouldn't have to pay the whole H&W payment on top of the healthcare, right? The healthcare cost would reduce whatever H&W payment DOL might think that you owe, assuming that they apply the SCA H&W requirements to FFCRA leave. So again, we wish, like all webinars right now, we wish we could give you 100% solid gold answers, but we hope that today we've been able to give you a better sense of how to read a lot of these regulations and laws and SCA requirements together. If you have any other questions, please feel free to reach out to either Sarah or myself. We appreciate that you took the time. I know everybody's busy and juggling, so we appreciate that you took the time to spend it with us today, and we hope you stay well. Sarah, anything else?
No, thanks everyone.
Thanks. Have a great afternoon.